This hearing is in the matter of case number TCD 001-2023 and is being held by way of video conference before Justice Wayne Martin. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is a litigant in person. Lead counsel is Mr. Nathan Landis. The defendant is represented by Norhan Abdulatif Al-Zabi Advocates and Legal Consultants, and lead counsel is Ms. Mariam Razak. Thank you.
Good. Thank you. Is there any housekeeping before I invite Ms. Razak to address? All right, over to you, Ms. Razak.
Good morning, Your Excellency. We represent the appellant in this dispute before you. I understand that you were the trial judge in this matter in regards to the instant hearing. As you are no doubt aware, Your Excellency, the construction dispute before you is within the jurisdiction of the DIFC courts. I trust that you're aware of the facts and the pertinent issues arising from the case, Your Excellency.
Yes, I wrote the judgment, and I've read all the submissions in support of the application for permission to appeal and against the application for permission to appeal. So you can assume that I've read everything relevant. There's no need to go into general background. You can go straight on with your submissions.
Thank you, Your Excellency. So as you're aware, we're here to seek permission to appeal the decision rendered by the lower court, and respectfully your judgment. Our contention is that the decision made by the lower court contains significant errors both in law and in fact that merit the intervention of an appellate court. The crux of the appeal lies in the complex contractual obligations. The statutory regulations and the factual matrix underpinning the construction project, which is in dispute. Our grounds for seeking permission to be appealed can be summarised follows. Firstly, Your Excellency, there was an error in the application of legal principles and contractual provisions. It is in the opinion of the appellant that the lower court misinterpreted and misapplied critical provisions of the construction contract, particularly those concerning the issue of retention and the awarding of interest on an unspecified agreed final account. Misinterpretation consequently led to an unjust allocation of damages to the respondent that disproportionately affected the appellant. Secondly, Your Excellency, there was an incorrect legal and factual finding. The trial court's factual findings were not only against the weight of the evidence presented, but also overlooked key testimonies and documentary evidence that support the appellant's position. Notably, as I've previously mentioned, Your Excellency, the issue of retention. I'm not sure whether Your Excellency wants me to go in detail to the contents of the skeleton argument at this initial.
No, I've read the skeleton. I've read the skeleton. As I say, all you need to do is speak to it. But my first question is, there are really three issues you raise on the appeal. The first is the retention. The second is the interest, and the third concerns the amount of the if you like, the reduction for the work on the rooftop. Now, were any of these issues raised below? Were any of these issues previously ventilated?
As I understand, Your Excellency, I wasn't lead counsel at the trial, as you were aware. But I have had the opportunity of reading the transcript and due respect, as Your Excellency may be aware, the appellant wasn't best represented at trial, and although they voiced their opinions as to the discontent, this wasn't conveyed to Your Excellency at the trial.
Well, that's you see, that poses a problem because, of course, the court is entitled to assume and must assume that legal representatives act with the authority of the client.
Of course, Your Excellency.
And have a degree of competence. If that's not right, then the remedy doesn't lie in this case. The remedy lies elsewhere, because we can't we can't go inquiring into the relationships between lawyers and their clients. So again, is the answer to my question that none of these grounds were raised during the trial?
Your Excellency, if I may, the issue of retention and the issue of interest came to the appellation once they were in receipt of Your Excellency's judgment. With regards to
could you just answer my question? Were the issues raised during the trial or not?
I think as far as I'm aware, Your Excellency, they weren't raised.
All right. Well, that's a problem, isn't it? So that firstly, you'll be aware under the Part 44, appeals are not by way of rehearing, unless the court otherwise orders, and you're not seeking that. So you've got to demonstrate error on either fact or law, and it's hard to see how you could make out an error in not deciding an issue that wasn't before the court. So how do you deal with that?
I propose, Your Excellency, with regards to the issue of retention, I think that was sort of addressed and skirted around at the hearing, even though it wasn't brought specifically to Your Excellency's attention.
As far as I've looked at the record, I can't find and I can't recall any assertion on behalf of your client to the effect that the various accounts that were presented by the claimant were wrong because they double counted the retention. And those accounts, first of all, they were presented in the negotiations. They're in the bundle you prepared for this hearing. There's the account presented shortly after the work was finished, which double claimed the retentions. You say double claimed the retentions. Then there was the account attached to the particulars of claim. That double claimed the retentions. Then there was account attached to the amended particulars of claim. That double claimed the retentions. And there are variations of those accounts produced during the hearing, all of which double claimed the retentions. And at no point did your client plead or did your counsel say that's an error. That's right.
Yes, Your Excellency. I totally agree with Your Excellency's assertions and observations. I think the issue here is that the instructions I have today, Your Excellency, was that the issue of the double claiming of the retention and the interest was brought only to the attention of the appellant when they were in receipt of your judgment.
Right. Well, it's not. Let me just go back. The cases say, and there's a case I don't know if you've seen the Blue Book. Case in the Blue Book, Demac Park Towers Company. So when there are issues raised for the first time on appeal, there are different approaches. One is to say, well, appeals aren't the opportunity for a second bite at the cherry. If there's an argument that should have been raised, it should have been raised. The other is that if there has evidently been an injustice and no evidence could have reasonably been led in relation to that issue, then the justice should be corrected. The injustice should be corrected. So you're, I assume, going to say that the issue I think, in other words, if it's possible that evidence could have been led in relation to the issue that you belatedly want to raise, then I think it makes it very hard for you to argue that appeal should be granted on that ground. But if you can establish that no relevant evidence could affect the position, then I think you've got an arguable ground of appeal. And I think we need to look at the grounds separately in that regard, because I can see your point in relation to the first ground, the ground in relation to the retention. So either that's right or it's wrong. And I can't see how any evidence would affect it. The evidence was there. It's a proper construction of the agreement. Clause 11 deals with retentions, and it's really quite straightforward. So I think, but on the other hand, when you go to the other grounds, I think it gets more complex. So if you'd like to deal with it ground by ground, I think that's the best way to go.
Yes,
what do you want to say? Is it convenient to go to the retentions? What do you want to say about the retentions?
Yes, Your Excellency. So if we address the issue of retentions firstly, I think if you just bear with me a second, Your Excellency, I'll go to the relevant section of the bundle. Firstly, Your Excellency, addressing the issue and the point with regards to anything in the bundle and whether it was brought to the court's attention, the expert report prepared by the appellant actually does raise the issue of the adding of the retention, and specifically deals with that issue. If you just bear with me. Yes, yes, Your Excellency, it's page 963 and 964
of the current bundle.
Yes, yes, Your Excellency.
963. Thank you. Very slow. Oh, here we go. 963. All right. Yes, I've got page 963.
Your Excellency, if you refer to the schedule there prepared by the expert.
Yes.
If you go down to the outstanding retention to be released on completion of works.
Did you see he's double counted it too, hasn't he? Oh no, he hasn't included it there.
That's right, Your Excellency.
Yes. But no point was made in the report that it was double counted.
Yes, Your Excellency. I think this was actually included within the trial bundle. I appreciate that no point was made to Your Excellency, but it's clear there that
even if you read this page, you can't actually see it. It takes Sherlock Holmes to work out that the expert is saying that the amount's been double counted.
I agree, Your Excellency.
You would have expected the expert to say, well, the figures are wrong.
Yes, Your Excellency, I'm totally in agreement with you. Yes. I've directed you to the relevant section of the schedule, and I appreciate your thoughts and sentiments that, it hasn't been sort of spelt out to Your Excellency, but it's clear from the schedule that the retention has not been added.
Yes. Well, that's for the MEP. Is there a similar page for the fit out? That's the next page, is it? Yes, there is the next page.
Yes, Your Excellency.
Yes, all right.
Can Your Excellency see with regards to the fit out where it says all retention released?
Released, yes, I see that. Yes, thank you. Yes, all right.
Yes, Your Excellency. I don't know how detailed you want me to go into the issues and arguments, given that it is a permission to appeal, but I can address you.
Your position in relation to retention is that you say, and let me correct me if I've got it wrong, you say that there's been a clear error here, that the account should never have been double counted, that a retention is part of the contract sum, not in addition to the contract sum.
That's really right. That's exactly what I'm saying, Your Excellency.
All right.
If you want me to expand further, I'm happy to do so.
No, I understand the point. I just wish somebody had made it to me during the trial.
No, but anyway. I totally appreciate that, Your Excellency, and apologies for that.
No, it's not your fault. Not your fault, Ms. Razak.
Secondly, with regards to the issue of interest, can I make my submissions in relation to that? It is our contention that the parties undertook and conducted the contract in accordance with UAE law, and it was a general understanding that UAE law would prevail.
Well, I think there's an express provision. I think it's the law of. I think the contracts expressly provide that it's the law of the UAE. I'm sorry, the law of Dubai, and the law of the UAE to the extent that it applies in Dubai.
Yes, exactly, Your Excellency. That's exactly the point. General consensus is there that no interest is to be applied under the laws of Dubai for delay. I can understand that.
Well, I can't decide the case on the basis of general consensus. You've referred in your
I will be referring Your Excellency. I will be referring Your Excellency to further case law, I think that was just the basis of the introduction.
Yes.
This is a construction dispute, Your Excellency, which occurred onshore. Therefore, the relevant laws I think we have established are the UAE laws. Furthermore, interest for delayed payment may only be claimed if the amount is known and stated. It's the contention of the appellant, Your Excellency, that the final account was only relied upon on the last day of trial.
Well, what's the source of the proposition that interest only runs if the amount is crystallised? What is that a statutory provision, or where does it come from?
I refer you, Your Excellency, to pages 87 and 88 of the current bundle and case reference number 458 of 2022-1006.
Sorry, page 87 and 88 of the bundle.
Yes, Your Excellency. Is Your Excellency at the relevant pages?
I've got page 87. Part of a decision from which court?
Part of the decision, Your Excellency, is it starts at the second paragraph on page 87.
Yes.
Whereas the appellant complains.
But what's the source of the law? Is the law of Dubai? It's not a common law jurisdiction.
No, it's not a common law jurisdiction.
So it must be a statutory provision. What's the statutory provision?
The statutory provision, Your Excellency, is, if you just bear with me, Your Excellency, I will. This case law was heard in the Court of Cessation, and that's where it emanates from.
Yes, but what's the statutory provision that establishes this principle?
Bear with me, Your Excellency. I will just refer back to my notes. If you just bear with me, Your Excellency. Yes. Your Excellency, I have not been furnished with those details in my instructions. My apologies. I've just made reference to, I've been just directed to the case law. It is the judgment of cessation. As I said, it is a UAE case which confirms the point that we are trying to make.
But the UAE is not a common law jurisdiction, Ms. Razak. If there is a principle, it has to be. So you can't take me to the statute.
I can't, unfortunately.
Well, it's an inauspicious start to the proposition that the appeal has significant prospects of success if you can't point me to the source of the law that you rely on.
Yes, sir, I totally agree with your assertion.
There's another problem. There's another problem too, isn't it? That is, if you could put your finger on the relevant principle, it must admit of exceptions, so that if the claim is for $1 more than the amount owing, surely it can't be the law that interest doesn't run. So then there must be questions of fact and degree involved. Now, if that's right, then had this issue been raised at trial, it could have and should have been investigated through the witnesses, and in particular the witnesses called on behalf of your client, as to, for example, to take an example, there were a number of variations. And in the end, the claimant trimmed its sails and only claimed for the variations that had been approved and agreed in quantum. But your client didn't pay those amounts. So what we would have done is investigated at trial the question of what your client knew was the extent of its liability, including, for example, liability in respect of those agreed and paid variations, but which weren't paid.
Yes,
so, and that's a problem.
Your Excellency, apologies, Your Excellency.
No, that's a problem raised. That's the problem arising from raising this ground late, because if, as I said earlier, if it could have been the subject of evidence at trial, then that's it. It's too late.
I appreciate and understand your submissions, Your Excellency, and totally agree with them.
They're not submissions, Ms. Razak, they're questions.
No, I totally agree with your questions and your line of questioning, Your Excellency. My point simply here is I totally agree with the way that the matter was dealt with at trial, and that these points should have been raised. Yes. What the appellant's submission is here is that they, in accordance with the laws of the UAE, this is a matter that, you know, when the matter wasn't quantified and the final account was only presented one day, well, on the last day of the trial, effectively, how can interest be awarded from the date?
Because there may be a substantial component of that final account which your client should have understood was due and owing. That's why.
I understand, Your Excellency. That's absolutely fine. I think the point that the appellant was trying to make here is that they were raising objections continuously, albeit it may have been verbally, but objections were continuously being raised on the account, and no final account was being agreed by the appellant.
But the appellant was saying, we don't owe you, you owe us money because of the delay in completion of the project, so we're not going to pay you anything. So that's as I understand the gist of the evidence.
Yes, Your Excellency.
So if the appellant should have known that there was at least a core of the claim which should have been paid, then interest would run. But the problem is we never got down to investigating what the appellant should have known because nobody took the point. But anyway,
I take your point, Your Excellency. The assertion is on the basis of the fact that the accounts were very different to initially what was initiated by the claimant at trial to what was actually awarded to the claimant at trial. It was a significantly less amount, and it should have taken into account that the delays were raised to the claimant up until the last day of the trial. I have instructions, Your Excellency, that it wasn't the fact that the appellant was trying to say we're not paying you anything. They raised objections on valid points and assertions throughout the course of the proceedings, and indeed prior to the proceedings. So that was the point that I was trying to make. Furthermore, Your Excellency, if there is a contract between two parties, the Commercial Code states that the creditor is entitled to interest as compensation for delayed payment under Article 88. It can be at the rate decided by the parties under Article 77. In the absence of an agreement, Your Excellency, it will be the prevailing market rate subject to a maximum of 12% under Article 76.
But here there was an express provision for the payment of interest at the rate of 15%, which is what I applied. So yes, is there any provision of the Commercial Code that would override that?
Not that I'm aware, Your Excellency. What we are trying to say, and the appellant is very much trying to say, and I take your point, Your Excellency, and I will actually leave it there if you disagree.
Yes. Yeah. Well, I think it's this ground is very hard, Ms. Razak. I think.
Yes, Your Excellency.
Yes, all right.
Yes, Your
Do you want to move on to the next one?
The final point, Your Excellency, is the deduction of the rooftop works.
Yes.
As I expressly stated, and I think there was some confusion at the date of trial as well, Your Excellency.
Well, I asked for information. I asked for information in relation to this, and nobody gave it to me. I asked Mr. Bowler, who had a statement in his report saying to be checked. I asked him if he could tell me anything about that, and he said no. And then I asked counsel for the appellant to take me through the items I asked him twice. I asked him before we adjourned for closing submissions on the third day of the hearing.
Yes,
I said that I expected counsel to take me through the items of final account and take me to any that they objected to. And I asked him again during the closing submissions, and he said nothing about this issue.
Yes, Your Excellency, I can fully appreciate your position at trial.
But the problem runs deeper than that, because it's the same as ground 2, and that is that if this matter had been investigated at trial, evidence could have been led. One of the documents was exchanged between two of the, as I note in my judgment, one of the documents was exchanged between two of the people who were witnesses in the hearing, and nobody asked them about it. And that's because nobody on behalf of the appellant had indicated that there was any contention in relation to this issue.
As far as I understand, Your Excellency, the issues had been raised with the claimant at trial and prior to a trial on numerous occasions. I'm not too sure.
It's not raised in the pleading. There was a pleaded final account which contained a concession of whatever it was, 161,000. And if you wanted to say that's inadequate and that it should have been 470,000, whatever it was, then you carried the burden of pleading that. You didn't.
Yes, Your Excellency, I totally understand your point. Is it worth me explaining the appellant's position with regards to the deduction of rooftop works?
Yes, you can explain it to me, but if it goes beyond the evidence, there's nothing I can do about it. But certainly go ahead, please.
I totally understand, Your Excellency. What the appellant is submitting in relation to the deduction of rooftop works was that there was a complete de-scoping of the rooftop works, which was totally different to the works that the appellant asked the claimant to carry out in relation to the rooftop toilets.
All right. Now how can you make good that point on the evidence before the court? Where is the evidence that enables you to make good that point?
Your Excellency, I think the documentation with regards to the rooftop, or can I take Your Excellency to the letter dated the 28th of July from the claimant, which is
that's D3, I think.
What D3, page 950.
Thank you.
Your Excellency, as you will note, the letter at D3 makes reference to the de-scoping of the work in relation to the rooftop work. Is Your Excellency?
Yes, I've got that.
This then brings
you go to page 20. Page 22 has the summary, and it sets out that the deletion works total 475,145 dirham. And if you look at it, the items as they're set out. So if you got, just take a note of water supply 3174 and drainage 6966. And I'll explain to you why that's relevant. Because then what happened then was that on the 28th of October,
yes,
there was other correspondence relating to the 18th of October. And is that in the bundle?
Yes, Your Excellency. The point that I was trying to make is at D3, on all of the correspondence, there is a specific reference to rooftop floor as opposed to rooftop toilets.
I see. Rooftop floor as opposed to rooftop toilets is the proposition.
Yes, Your Excellency.
Except that it's more than just the floor, because there's a whole lot of electrical works, and emergency and fire alarm works, and air conditioning works.
Yes, yes, Your Excellency. That was in relation to all of the works on the rooftop floor, just rather than the rooftop toilets. The contention is that this related.
So it's all of the work on a particular floor. Not the floor, not the ground, not like the thing you walk on, but all of the work in an area.
That's right, Your Excellency.
All right. And then the work that was restored was in relation to the toilets, was it?
It wasn't actually restored, Your Excellency. The point that the appellant was trying to make at trial and failed was that the rooftop toilets work was not actually on the rooftop. It was actually on the first floor. The rooftop toilets were actually located on the first floor and were already consistent.
Where's the evidence of that?
If I point you to the report sorry, the letter of the 19th of October, if I'm not wrong.
Yes.
18th of October, apologies,
Yeah.
Your Excellency, at page 986, tab D6.
6, just bear with me. Yeah. Yes.
The point and the submission
Well,
I am trying.
This starts. Please find the attached BOQ for the deletion of roof, floor, elevate estrance for your review and necessary action.
Yes, Your Excellency, the point I am trying to make with regards to this is that the letter dated the 28th of July 2021 and the email dated the 18th of October 2021 relate to the same matter, the rooftop floor, as opposed to the rooftop toilets which were included in the contractual amount and were never descoped.
Well, this sets out the way in which the figure, this document sets out the way in which the figure was arrived at, the figure of 100 and wherever it is. It's at page 9
9 of the
document.
Yes, Your Excellency.
Now that sets out the amounts. And if you go, for example, see, this is the point I was made. If you go back to page 7, some of the items are the same. So the water supply and drainage, they're the same amount. So these are the same. So what you're saying is that both of these documents relate to the same thing.
Yes,
but not the rooftop toilets. But this document produces a net figure of 161,404, which is the figure that's been included in the account.
Yes, Your Excellency, I totally agree with your assertions, but the point that I'm trying to make is that there is a significant reduction from the original letter dated the 28th of July 2021 to the email for exactly the same descoping of the rooftop works, which is then.
But how do I know what the difference is? Somebody should have got in the witness box. These emails were exchanged between 2 of the witnesses. Why didn't somebody ask any of the witnesses about it? You're asking me to infer. These documents are obscure, and you're asking me to conclude something from these documents. I just can't see how I can do it. And the other, while I'm talking, and I'll give you a chance in a minute, the approach I took at trial was to say, the approach I took in the judgment was to say, well, the claimant, both from its original accounts and its original particulars of claim, conceded a reduction in scope of 161,404.98. If you asserted that reduction was inadequate and should have been 475,000, you had every opportunity to say so, but you didn't.
I totally agree.
And there was no evidence led to support it, and it's just too late, isn't it?
Your Excellency, if I may, on page 8 of 9 of the report, yes. I totally agree with your contention that this should have been brought to your attention, but it clearly refers to deletion of scope of works for the rooftop works. So this should have been definitely brought to your attention, and someone should have got into the witness box and referred to that. But it is clear from page 8 and 9 of this email that was the scope of the deletion of works for the rooftop works.
But if you go to page 8 and 9, that's page 9 is the source of the figure that ended up in the points of claim. So on the face of it, it's a regular figure. It's justified by this document, and there's no evidence to suggest that the figure is wrong. So why would I take this? This figure is later in point of time than the figure of 475,000 in July. Why wouldn't I assume, in the absence of evidence to the contrary, the October figure is right?
If you just bear with me, Your Excellency, I'm just going to refer back to the previous report. Page 942, if I can direct Your Excellency to the page of 942.
Still coming up on my machine. Here it is. Yes, I've got it now.
Your Excellency, you can then refer back to that, which also confirms the deletion work, the scope of the deletion works for the rooftop floor.
But the figures are different. That's the point I'm making. The figures in July are different. The figures in July came up with a deletion of scope valued at 475,000. The figures in October, which appear to be dealing with the same work, came up with a deletion in scope of 161,000. So one would have thought that the later in point of time is the right figure, and it was the figure that was contained in every statement of account that I've ever seen, and nobody ever challenged it in either any pleading or any evidence or anything.
I appreciate your difficulty, Your Excellency.
Well, it's not my. I think it's your difficulty, actually, Ms. Razak. I don't think it's mine.
I appreciate your difficulty at trial, Your Excellency. Yes. I appreciate that it's my difficulty at the present time. Yes. But the point that I'm trying to make is that from the letter of the 28th of July 2021 and the email of the 18th of October 2021, that the deletion of the scope of works is sort of the same. And as you've stated, for the same deletion, there are two different figures. Now, my point, Your Excellency, is that this was raised with the claimant on all occasions that the appellant possibly could. I don't have any further instructions as to why this was refuted, but it was never agreed. And it was always refuted by the appellant that, you know, there are two different sets of figures.
Well, except in any pleading or any evidence or any statement of the court.
The assertion, Your Excellency, I think, was that it was correctly stated in the letter from Bond, and that was where the reliance came.
Anything else, Ms. Razak?
The point that I'm trying to make, Your Excellency, is that the detailed breakdown that was presented is exactly the same, but in the letter of the 18th of October, the unit prices were left out, but essentially it is for the same works and there is a significant reduction. I think that's my point in relation to the MEP rooftop works, yes, Your Excellency. Right. Your Excellency, if I can continue, and I won't take much more of your time, the issues that I've raised, particularly in relation to the retention, are a significant issue, and in relation to the retention, I think that there are real prospects of successfully asking the court to allow the appeal on those grounds. With regards to sort of, it raises also questions if the appeal isn't to be allowed on the significant public interest concerning the interpretation and enforcement of construction contracts within the DIFC. Which may...
I think that's a bit of a stretch, Ms. Razak. I think we all know what a retention is, just that in this case nobody drew to my attention that they'd been double counting.
Yes,
so I don't think there's any point of principle here.
No, Your Excellency, I agree. I think the merits of the appeal, the most strongest ground of the appellant's case is the issue of retention, and it is on that sole ground that I respectfully asked the court to allow permission to appeal.
Yes, thank you. Thank you, Ms. Razak. Mr. Landis.
Thank you, Your Honour. I don't propose to address, Your Honour, on the second ground. I will stand on the submissions that I've made in writing on that one. In relation to the retention amount, the issue is whether or not that amount is included somewhere else in that final account. For example, amount received, including advance payment or partially in the balance advance to be recovered. The issue that the...
Sorry, I'm not following you, Mr. Landis. Can you explain that? I didn't understand what you just said.
The issue is, Your Honour, it's not necessarily a simple case of a one line of the statement of final account. The point that I haven't been able to get to the bottom of is whether or not that outstanding retention is included somewhere else. For example, in the received
as a
amount.
credit. As a credit.
Yes.
Where could it be as a credit?
And include, well, this is the issue, Your Honour, whether or not it was part of the received amount, which is the 5.476740.45 fills. That's an issue that could have been explored at trial, but wasn't, because these amounts were agreed by the appellant.
Well, on the face of it, it doesn't look like that on the final account. It's got, why would you do it that way? Why would you claim for the retention and if the amount had been paid? But you did it. You did it right. It was in your first account, in the account that you first rendered.
As a deduction.
As an addition. So I think it's D2 in the bundle. If you've got particularly good eyesight, this is the account I think that was rendered long before proceedings were started, and it was claimed twice there. Now, why would you do that if it had been paid?
Apologies, Your Honour. D2 is taking its time.
Yeah, mine too. Mine too. Probably the quaint internet we've got in Australia, Mr. Landis.
I need to pedal faster, Your Honour. While that's loading, I'll deal with the other point, Your Honour, which is that this was the subject of a concession by the appellant below.
Where's that concession?
So the concession was during the closing address. If Your Honour goes to page 31 of the transcript, which hesitate to do it, but it's part of the case bundle as well.
Yes, all right. That's D8. Okay, I've got that now. Page 31 of the transcript.
Yes.
That comes up a lot quicker than D2 for some reason.
And Your Honour will see at the middle of the page, Your Honour asked a counsel for the appellant, are there any other aspects of this account you dispute? And he says no. Well,
that's not so much a concession, really. It's not express concession dealing with this. I mean, on the face of it, it's wrong, isn't it? On the face of it, you can't claim the amount claimed and the retention.
If that is correct, then yes, Your Honour, I accept that as a proposition.
Well, do you have any instructions on whether the retention was in fact included in any of the credits on the final account?
I don't, Your Honour, no. It's of all of the grounds.
If it wasn't, then you have you've got no. The appeal would have to succeed, wouldn't it?
Well, it would need to go to the next stage, yes, Your Honour.
Well, on the face of it, the decision is wrong, isn't it? Clearly.
Yes, Your Honour.
And you can't. You don't know whether you want to lead any evidence to say that there was in fact a credit given for those retentions.
No.
On the face of it, and the final account, they're described as outstanding retention. So it would be that would be an odd way of describing something that had been paid.
Well, that's yes. Well, that's I suppose part of the point, Your Honour, is that it hadn't been paid because the retention was partial. 50% was due at the TOC and the other 50% at the FCC.
Well, Mr. Landis, all I think I can do is, this is on the face that looks wrong. And you accept that, subject to what you say, if the point had been taken, there might be evidence, but you can't say there would have been evidence.
That's the case, Your Honour, yes.
Well, then I think the best thing would be for me to grant leave to appeal on this ground. And then if you want to apply to lead evidence at trial on the basis that the point wasn't taken below, you can do so.
Yes, Your Honour.
But if you haven't got any evidence of that kind, I think the prospects
relatively short appeal.
I think it'd be a very short appeal. Well, I've actually done the figures. It makes a big difference. It comes out, it's about 1.2 million dirham because it has knock-on effect for the interest.
For the interest, yes.
Yes. So,
yes. Yes, Your Honour.
So, well, is there anything more we can usefully do today?
No, I think that's all from me, Your Excellency.
Mr. Landis, anything more you want to say?
No, Your Honour.
All right. Well, I'll reserve my decision, but you'll understand what it's going to be.
Yes.
So there will, and Mr. Landis, that might be relevant to the. I don't know if you've got any enforcement proceedings on hand, but you might want to stay your hand in relation to enforcement of at least the part that relates to the retentions and any interest on them until we get a bit further down the track.
Understood, Your Honour.
Yes. All right. All right. Well, I'll give formal order and reasons as soon as I can, but we'll see how we go.
Thank you so much, Your Excellency.
Thank you, Counsel, for your assistance. Thank you. That concludes the hearing.
Thank you.
Thank you.
Thank you so much.